Hey folks, I'm attorney Roger P. Foley, and this morning I was having breakfast over at Nick's Diner in Palm Beach, and I get a call of a gentleman who would like me to represent him in another jurisdiction. He's I guess he's seen me on YouTube and did some research and what have you. So I start to talk to him, and can't disclose any facts, but I can kind of explain to you the gist. In an effort to protect another person, he came into contact with two people, and one person was hit the other person with like a bottle or a can, and he intervened to protect the first person. Now, clearly, if those are the facts, you can file a motion. You can file a motion to dismiss based on stand your ground or self-defense of another. Well, the attorney that he hired got him into a pre-trial intervention program, but he was looking to explore defenses. So as I say, and I said in a video not too long ago, you either plea or you fight. So I said to him, I go, look, you can hire me, and your jurisdiction's, far away, and I'm probably going to charge you 15 to 20 grand on this case. That's reality, right? It's a 3rd-degree felony, and I got to travel, and you're going to pay for my time and my energy and my expertise. But he's a businessman, and he can afford it. So I now have an ethical duty to explain to him, listen, if you enter pretrial intervention, it's a guarantee. You do what you're supposed to do, case gets dismissed. If you hire me, although I'm good, I can't guarantee a victory. So let's think about it this way. If I file a motion to dismiss and it is denied, if it's denied, you're probably going to get, I don't know, it depends on the jurisdiction, 3, 4, probably 3 years of probation. It could be 2, it could be 3, it could be 4, right? Years of probation. But now you have that on your record, and would be, a felony battery charge. So which is easier, pretrial intervention or probation? My humble opinion is probably pretrial intervention. But I get it. You want to stand on principle. No problem. I love people that want to stand on principle, sir. So let's go through the worst case scenarios. I file my motion. The judge says, Mr. Foley respectfully denied, but yeah, you can present that defense to the trier of fact, to the jury. Now I go to a jury trial. Now let's say, I don't know, they don't like my tie, or my collar stays aren't in, or they don't like the way I present the defense, or they don't like you, my client, or they're very sympathetic to the alleged victim, or the prosecutor's just super, and they find you guilty, whatever the reason, right? There's a multitude of reasons with juries. It's not always about guilt and innocence. They find you guilty. Now you are a convicted felon, and it's a felony case, so you're probably going to do time. I don't know, maybe you do 364, maybe you do a year and a day, maybe you do 18 months. Maybe the judge gives you some kind of probation, maybe, or a combination. So if you look at it that way, and you make a decision, I really don't want to do a pretrial intervention. I get it, I'm principled too. And I would have a real struggle with coming to a decision on whether or not I wanted to enter in or admit that I did something and go into a program for a year or 18 months if I didn't do anything. But it all comes down to here, folks. Are you strong enough? Quit attacking the lawyers. Are you strong enough to deal with the consequences, win or lose? If your attorney got you into pretrial intervention, you can say no. It's absolutely your right, and I respect you for saying no and wanting to fight. But If your new attorney, RP Foley, loses that motion, now you got to take probation or you go to trial. Are you willing to take probation over a pretrial intervention? Probably not. It's probably going to be longer. Are you going to, if you lose a jury trial and end up in a prison cell or a jail cell and a convicted felon, are you going to think about, I should have just did that. I'll do that diversion. Well, now they can. So the guy says to me, so you're saying I should do the pretrial? No, I'm just making you aware I am not God. I am not all powerful. I don't walk into courtrooms and the seas part and judges go, hey, Mr. Foley, hey, Mr. Foley. I would love that. Love that. But it doesn't happen unless I'm bullshitting you. They go, sir, you're Mr. Foley. When I go to different jurisdictions, they don't know who I am. Right? Who am I? I'm just a regular attorney. I'm no special than, the attorney that you see on the billboard or the attorney you find online or the YouTube or whatever. I'm a defense attorney. I'm passionate. I'm educated. And I work to get better. And I care about my clients and I answer calls. That's what makes me different. Right? I hate to say that, but I get so many calls about people saying, hey, thank you for communicating and helping me understand and this and that. But what does it come down to? Shut up and take your licks, take pretrial intervention, or be ready and willing. If you win, great. If I win that motion, I'm happy, you're happy, everyone's happy. If I lose that motion, you're like, oh shit, I got to go to trial. And now if you lose, nobody's happy, right? And I said, you can't go blaming the attorney. If Pacquiao and Floyd Mayweather go 12 rounds and it's a close decision and Mayweather inches him out by, a majority decision, do you hate Pacquiao for fighting and giving his all? All I can do and all any attorney can do is give their all. It's you, the client, the person who's been alleged to commit a crime. Are you mentally prepared to fight the battle and the consequences that could possibly come with a loss? You have to decide. Let me know what you think. See ya!